600. The bank assumes no liability for form, sufficiency, accuracy, genuineness, falsification, or legal effect of any documents. And we state that this article not only establishes the limits of bank's responsibility, but also shows up the limits of powers of examinations that the bank has. And it's especially evident if we look at the previous publication of UCP, it means UCP 500. And in that document there was established a so-called standard of reasonable care. However, we do not see any reference to this standard in UCP 600. So the scope of bank's examination were limited in UCP 600, and therefore the bank had no powers to examine the validity of this signature. Proceeding with the second issue.
Before you proceed,
okay.
do you have any questions? Just to finish off this one section, I understand your position with respect to UCP 600 and what the obligations or the rights of the bank are or not, but doesn't the bank have an overriding obligation to prevent fraud, and isn't there a very strong public policy concern which would cut through the UCP 600 requirements, if that was a concern, or is that not a relevant consideration?
Yes, we state that this consideration is not relevant due to strict compliance principle. And also we'd like to put the tribunal's attention to the fact that there is no unified practice of applying so-called fraud rule. And we state that this rule is in general is not arbitrable, because the requirements of laws that establish such a rule are mostly provided by the national laws. And in this case, no national law is applicable. So therefore we find that any reference to fraud rule is unacceptable in the present case.
Thank you.
So proceeding with the third issue concerning the national ship passenger certificate, we state that, as our opponents have already admitted, there is an ambiguity in provisions of the letter of credit. Firstly, as I already explained, there is a reference, the paragraph 10, to the shipbuilding contract. And there is a reference to the UCP in the paragraph 11 of the letter of credit, which in its turn prohibits to make any reference in the letter of credit to the shipbuilding contract. And in that regard, it's obvious that there is an ambiguity between these two provisions. So we would like to put the tribunal's attention to our two arguments with regard to interpretation of this ambiguity. First is, as it was already mentioned, it's contra-preferential rule, which with regard to that rule, any discrepancy in the document must be interpreted against a party that supplied the term. And in commercial practice, it is the bank who supplies the final terms of the letter of credit, even though it acts on the instruction received from the buyer. Our second argument is that provisions of UCP 600 are standard terms, and provisions of paragraph 10 referring to the letter of credit, the shipbuilding contract, are specific terms. And as far as standard terms, contract with specific terms, the latter prevail. With that regard, the list of the documents mentioned in the shipbuilding contract prevails the list of documents in the letter of credit. And proceeding with the third issue concerning whether the claimant made compliant presentations. So, if on the basis of the previously submitted arguments, we see that all the documents were compliant and the presentation all was made compliant. Therefore, there was an obligation of the bank to effect the payment. However, it did not. We would also like to put the tribunal's attention to one additional moment. This has already been referred by my colleagues, that the bank, before making an examination, submitted a letter to the buyer in which showed the buyer the list of documents which were presented by the claimant. As it comes from ICC application 645, called Leading Cases of Letter of Credit, from the analysis that is made by authors of these applications, it comes that the only possibility of the bank to show the buyer the list of presented documents, the only opportunity for the bank appears when the bank has already made an examination. And in our case, the bank previously even not showing any discrepancies in this letter, submits the list of documents to the buyer. And we may understand this as consultation with the buyer in order to identify the buyer's opinion on the presented documents. And it contradicts the principle of autonomy of the letter of credit. So, with that regard, we state that with regard to the letter submitted by the respondent to the buyer, the bank violated its obligations under UCP. Concluding my position with regard to all the substantive issues, we would like to state that due to its unlawful actions, the respondent indebted the claimant $11 million, which is a general sum of debt. Also, interest calculated at this sum, and we would also like to ask the tribunal to put all the procedural costs on behalf of the respondent.
I think I have one question here. I understand your position that the list of documents in the shipbuilding contract should prevail. I think I still struggle with it because I see that the letter of credit expressly mentioned in the list of documents to be presented the National Passenger Ship Safety Certificate. And so one question that may arise here is whether the letter of credit being a more specific document to the relationship between the two parties, so between the bank and you in this case, whether this specific list in fact overrides the list in the shipbuilding contract because it is a more narrow, more specific list which applies to this narrow relationship.
Thank you, I see your point. With that regard, we'd like to admit that even not putting attention to quantity of documents in the first list and the second list, which most important in this case is that the bank, when issued the letter of credit, expressly established that the letter of credit issued without prejudice to the provisions of the shipbuilding contract. And by its so-called waiver, the bank admitted its liability to follow the provisions of the shipbuilding contract and also to follow the list of the documents presented in the shipbuilding contract. If the bank had any doubts with that regard, it should have applied to the letter of credit to verify which documents are listed there. But the bank failed to do so or didn't want to do so, and therefore the list of the documents in the shipbuilding contract should be considered prevailing.
And referring back to your reply, but the bank is not a party to the contract. However, the bank is a party of the letter of credit. Why should it consider another document which is not a party at all, and not consider the list which is in the document which is a party?
Well, we stated actually by referring to the shipbuilding contract in paragraph 10, bank partly made itself a party to the contract. It took an obligation to follow the provisions of the letter of credit, which considers actually the bank. And the list of the documents listed in the shipbuilding contract is one of the issues that should have been considered by the bank when it issued the letter of credit.
To clarify the position, we consider that the shipbuilding contract has three parties: the claimant, the respondent, and the buyer.
But then how do you deal with the respondent's point that to some extent this makes it abstract?
Yes, we see this point. However, we consider it does not make it absurd because it is absolutely clear from the shipbuilding contract what are the obligations of the seller, what are the obligations of the buyer, and what is obligation of the bank. It's clearly stated that the bank should issue the letter of credit. So it would be absurd to apply the provisions of the obligations of the seller and obligations of the buyer to the bank.
So, dear members of the arbitration panel, my name is Berioza Artur. I will present the defendant's position of Ms. Lex Mercatoria. My speech will consist of 4 parts. And first of all, I would like to elaborate that we didn't follow the buyer's instruction, as the claimant stated. The act of acceptance was not presented properly. The other documents required by the letter of credit were also not presented properly. And the fourth, the last one part that logically comes from the previous 3 is that all claims of Lex Yachts should be rejected. The submission of the documents presented on the 7th of March 2016 was not appropriate. As the claimant correctly stated that the submission was the claimant's invoice of the yacht, the certificate of quality of the yacht, the certificate of origin of the yacht, and the act of acceptance. Shortly after receiving the documents, we sent a polite letter to Ms. Yachts. After short review of receiving documents, we are planning to honor the presentation and effect payment of USD $11 million. But that doesn't mean that the analysis of the presented documents had already been conducted. It was just our politeness. And then, after a short review, when it actually took place, we discovered some discrepancies. And after that, only after a review, we've conducted Mr. Abazov according to UCP 600, paragraph 16. The fact that we contacted Mr. Abazov before the review was not proven by the claimant. Now let me proceed to the second part.
Sorry, I'm confused here because if we look at the letter on page 29,
Yes.
as I read it, it's the letter from the bank to the buyer. It's not the letter from the bank to the claimant. Why I'm missing something? Is it any other letter you're referring to, or?
Yes, but the letter, we reviewed the documents on the 7th of March, and on the 7th of March we contacted Mr. Abazov. On the 7th of March we were presented. We made a short analysis. We found 2 main discrepancies. We decided that according to Article 16, when an issuing bank determines that the presentation does not comply, it may, in its sole judgment, approach the applicant.
That's true, but where here the discrepancy? So what I'm confused, I think, here about is what are the discrepancies that you find, which this letter evidence and which justify you wanted to buy it?
Well, we are enclosing all the documents. We're enclosing all the documents and asking him for review, thinking that supposedly there are some discrepancies. And we found 2 of them.
So you never expressed that to Mr.
Well, not in this letter. Well, may I proceed? So let's move on to the act of acceptance as the key point.
Sorry, I just wanted to ask one question on this last point. How do you respond to the arguments that you had no right to look at credit cards or any other evidence that you had within the bank's
I will proceed on this later. According to international standards of banking practice and UCP Article 14, data in a document, when read in context with the credit, the document itself, and international standards of banking practice, must not conflict with data in that document any other stipulated documents of the credit. And I would like to draw your attention. Well, you quoted it correctly, but you didn't apply it in that way. I'd like to draw your attention that on page 28, the signature of the act of